We have heard learned counsel for the parties at some length. It is true that the trial court had, while discharging the accused person under the special act mentioned above, made certain observations about the alleged misuse of the provisions of the said act by unscrupulous elements and also certain suggestions for remedying that situation. It is also true that the trial court had come to the conclusion that there is no real basis for it to frame any charge against the accused person under the said act, but it is equally true that while setting aside that order and directing a fresh order on the question of charge, the High Court has clearly mentioned that the trial court shall remain uninfluenced by the observation made in its earlier order. That observation is, in the opinion of the High Court, a sufficient safeguard against any possible prejudice to the complainant appellant herein making transfer of the case from the court at Rohini to any other court unnecessary. Now, in the ordinary course, if an order passed by the court is set aside, the observation and finding recorded therein also get obliterated for all intents and purposes. So also, if the High Court make the position clear that any such observation shall not influence the court concerned while making a fresh order, the same should ordinarily put the matter beyond the pale of any controversy. Para. Having said that, there may still be situations where the nature of the observations made by the court concerned create a reasonable apprehension in the mind of the litigant that the court has so committed itself to a given approach or thought process that it may not be possible for it to retrace its steps to take a fair and non-partisan view in the matter. The present appears to be one such case where, despite the safeguards provided by the High Court's observation, the apprehension of the complainant continues subsist. We do not think that such apprehension is wholly misconceived, nor can it be dubbed as forum shopping in disguise. The earlier order passed by the trial court is so strongly worded that it could in all likelihood give rise to a reasonable apprehension in the mind of the complainant which cannot be lightly brushed aside. We must hasten to add that we are not in the least suggesting that the presiding officer of the trial court is totally incapable of adopting a fair approach while passing a fresh order, but then the question is not whether the judge is biased or incapable of rising above the earlier observations made by her. The question is whether the apprehension of the complainant is reasonable for us to direct a transfer. Justice must not only be done, but must seem to have been done. A lurking suspicion in the mind of the complainant will leave him with a brooding sense of having suffered injustice, not because he had no case, but because the presiding officer had a preconceived notion about it. The state government is entitled and empowered to fix the age of consent. The state can make reasonable classification, but while making any classification, it must show that the classification has been made with the object of achieving a certain end. The classification must have a reasonable nexus with the object sought to be achieved. In this case, the justification given by the state is only that it does not want to punish those who consummate their marriage. The stand of the state is that, keeping in view the sanctity attached to the institution of marriage, it has decided to make a provision in the nature of exception 2 to Section 375 IPC. This begs the question as to why, in this exception, the age has been fixed as 15 years and not 18 years. As pointed out earlier, a girl can legally consent only after she attains the age of 18 years. She can legally enter into marriage only after attaining the age of 18 years. When a girl gets married below the age of 18 years, the persons who contract such a marriage or abet in contracting such child marriage commit a criminal offence and are liable for punishment under the Act. Para. In view of this position, there is no rationale for fixing the age of 15 years. This age has no nexus with the object sought to be achieved, maintaining the sanctity of marriage, because by law such a marriage is not legal. It may be true that this marriage is voidable and not void ab initio except in the state of Karnataka, but the fact remains that if the girl has not married before the age of 18 years, she has right to get her marriage annulled, irrespective of the fact that the right of the girl child to get her marriage annulled. It is indisputable that a criminal offence has been committed, and other than the girl child, all other persons, including her husband and those persons who were involved in getting her married, are guilty of having committed a criminal act. In my opinion, when the state on the one hand has laid down that abetting child marriage is a criminal offence, it cannot on the other hand defend this classification of girls below 18 years on the ground of sanctity of marriage, because such classification has no nexus with the object sought to be achieved. Therefore, also exception 2, insofar as it relates to girls below 18 years, is discriminatory and violative of Article 14 of the Constitution of India. There are many other offences where the husband is either specifically liable or may be one of the accused. The husband is not given the immunity to any other penal provision except in exception 2 to Section 375 IPC. It does not stand to reason that only for the offence of rape the husband should be granted such an immunity, especially where the victim wife is aged below 18 years.